Hello viewers, you are watching Geo National News. Today on this broadcast we have with us Advocate Shakir Mahmood Khateeb, who presently practices at Honorable Supreme Court of India along with High Court of Delhi and High Court of Jammu, Kashmir and Ladakh. Having a specialization as a criminal defense lawyer and known for his articulate argumentations, besides having other artistic interests, he is known to have conducted trial in several cases of national importance, like Upar tampering case, and is also honored with several reported judgments of High Court. Presently, he is officially representing New Delhi Bar Association as a legal counsel and known for his renowned work. He is honored with a memento by New Delhi Bar Association. Besides this, he also deals with PMLA, Money Laundering Enforcement Directorate and CBI matters in Delhi and across India from last 10 years. Hello Mr. Shakir, welcome to our broadcast.
Thank you, Sujad, for having me here and for such a long intro. I really feel honored.
Mr. Shakir, would you please enlighten us with respect to the trial in check bounce cases?
Shuja, in common parlance, what you call as check bounce case, technically speaking, we say that this is a complaint under Section 138 of Negotiable Instruments Act. But before understanding the broad stages of complaint under 138 of Negotiable Instruments Act, we need to understand three legal entities. Number one is a person who issues a check, and he is legally called as a drawer of a check, who draws a check in favor of a person, and a person who receives a check or in whose favor the check is drawn is called as a payee. And number third is a legal entity before whom the check is presented. It is called as a drawee. It is generally a bank concern. Broadly speaking, the stage of a criminal trial is divided into two main stages. One is a pre-trial stage, and the pre-trial stage mainly consists of 6 sub-stages. And then comes the post-trial stage. The pre-trial stage commences right from the day of an issuance of a check which gets dishonored. Once the check is dishonored and is presented before the bank concerned, the concerned bank issues a return memo signifying the reasons for which the check has been dishonored. This completes the stage first of a pre-trial stage. Now comes the stage second. Once the return memo is received by the payee of a check, he is then required to issue a legal demand notice within the stipulated period of 30 days from the receipt of a return memo from the bank concerned. Then comes the stage third. Once the legal demand notice is issued in favor of a drawer of a check, if the drawer of a check does not respond or does not pay the amount due in favor of a payee, then the cause of action accrues in favor of a payee or the person who has received a check to file a complaint case under Section 138 of Negotiable Instruments Act against the drawer of a check. And here the drawer of a check culminates into an accused person and the payee of a check culminates into the complainant. Once he files a complaint before the concerned magistrate who has the jurisdiction to entertain the complaint is the magistrate generally in whose jurisdiction the bank concerned is situated. He examines the complaint and the document is therewith, mainly the return memo and the legal demand notice, and then examines the complainant on an oath, what we call as a pre-summoning stage, and sees if there are reasons to proceed against the accused person or to proceed against the drawer of a check or not. On the receipt of a complaint by the magistrate concerned examines the complaint on an oath and applies his mind whether there are sufficient grounds to proceed against the accused person or not. If the magistrate concerned feels that there are sufficient grounds to proceed against the accused person, the magistrate concerned can issue a summons. And if the accused person does not appear on the summons, the magistrate concerned can issue warrants. And if yet the accused person does not appear, the magistrate concerned can issue the non-bailable warrants against the accused person. And yet if the accused person does not turn up before the court, the magistrate concerned can proceed against the accused person under Section 82 of Old Criminal Procedure Code, which is a Section 84 of BNSS, Bharatiya Nagrik Suraksha Sanhita, which provides for the proclamation. That is, generally the proclamation is issued against that person who does not appear when the non-bailable warrants are issued against the accused person. On this count, there is very important judgment of Honorable Supreme Court of India, which basically came from the Honorable High Court of Delhi into Tyagi versus State of NCT, wherein the Honorable Supreme Court later on gave a detailed procedure to be adapted in order to secure the presence of an accused person in a criminal cases especially. and it provides that if the accused person does not turn up, if the bailable warrants, the non-bailable warrants, and the procedure under section 82 and 83 of Old Criminal Procedure Code is adapted, if he does not turn up, then what is required to be done in order to secure his presence before the court? This completes the pre-trial stage in a criminal case under section 138 of Negotiable Instruments Act. Now commences the post-trial stage. The post-trial stage commences mainly at the time when the accusations which are placed in the complaint are read to the accused person, and he stated whether he pleads guilty or he claims trial. And this is a very important stage, looking at the instance of an accused person in order to show his defense or in order to make his defense at a later stage. This provides a kind of a platform to the accused persons in order to make a defense at a commencement of a trial, wherein he could state the reasons for which the check has been issued. Like he could state to the court that at the time the check was issued as a security check, or the check was not provided to him, or check was stolen, or he has not signed the check, or many other reasons. At this stage is very important for the accused person, and he must make his defense. So when he is going to cross-examine or when he is going to lead his evidence at the evidence stage, he must bear these things in mind, what he is going to do. Then he must say these things to the court at the time of framing of a notice. Once the court frames a notice under section 251 of Criminal Procedure Code, then comes the stage 8th, where the court examines the complainant and the witness therewith, and also exhibits the documents, particularly the return memo issued by the bank and the legal demand notes issued by the payee or by the complainant. Then the accused has a right to cross-examine the complainant and his witnesses in order to demolish the case of the complainant and to establish his own case. The accused person has a right to give a statement under section 313 of CRPC, wherein all the accusations are again read to accused person, and the accused person gives a statement, the reasons for which the check has been dishonored, and what prompted him to issue the check in favor of the complainant. And after this stage, the accused has a right to lead his defense evidence in order to establish his own case, in order to show important ingredients. Number one, that the check was not issued for the debt which was legally enforceable. Or in other ways, we could say that a complainant, when he presents a case complaint for the court, he has to prove three important ingredients. Number one is that the check was issued for the legally enforceable debt, and the check was presented within the span of 3 months. And number third, that the check got dishonored because of lack or insufficiency of funds. And number fourth is that he issued a demand notice in favor of a drawer, claiming the amount due in favor of him. While leading the defense evidence by the accused persons, he must bear these things in mind, that he has to demolish the case of the complainant in order to demolish these three key ingredients. Number one is that the debt was never legally enforceable, number one. And number second, that the check was never given to him, or in certain circumstances that the return memo was issued for the purpose, some other purposes rather than the insufficiency of funds. Like there are circumstances where the check got dishonored, but the reason is not merely the insufficiency of a fund, but some other reasons. Like in certain circumstances, there could be the reason where the drawer of a check has issued a security check, and later on he has went to the bank and has stopped the payment. So the consequences would vary in those circumstances where the accused person or where the drawer of a check has went to the bank concerned and has stopped the payment. Maybe in those circumstances, the complaint under section 138 would not lie against the accused person. And all these things should be borne into mind by the accused person while leading his defense evidence in order to establish his own case against the complainant. And this completes the stage of a criminal trial under section 138 of Negotiable Instruments Act. And then comes the final stage, wherein the court hears both the parties. We call that as a final argument, where the arguments are led both the parties, and court finally decides the case either in favor of complainant or in favor of the accused person. Here it is very important, if the case is decided or if the complaint is decided against the accused person, normally the punishment prescribed is imprisonment for 2 years and fine, or the court can impose both the imprisonment or the fine to the tune the double amount of the check. If the accused is aggrieved of the order, or if the accused is aggrieved of the conviction, he can assail the order before the appellate court. Generally, he files a first appeal before the sessions court. And if yet he feels aggrieved of the order passed by the sessions court, he can approach a high court, filing a petition under 227 of Constitution of India, assailing the order passed by the sessions court. Yet if he feels that the order is passed against him by the Constitutional Court under 227, then yet he has again a remedy. Still, he has one of the options that he can approach the Supreme Court by filing a special leave petition assailing the order passed by the High Court. So this completes the generally the trial of criminal trial under Section 138 of Negotiable Instruments Act.
Shakir, is there any possibility of compromise in check bounce cases, and at what stage the parties can enter into compromise?
Technically speaking, Shuja, the offence under Section 130, it is a quasi-criminal case. And the procedure adapted is mainly the regulatory. And the courts are more inclined to pay the amount due in favor of a victim rather than punishing the accused person. Therefore, at any stage of a trial, even at a post-trial stage or even at appellate stage, even before the High Court or before the Supreme Courts, the parties can enter into a compromise and the accused person can pay the amount due in favor of the complainant at any stage. And there is a very important judgment of Honorable Supreme Court of India, Dayavati versus Yogesh Kumar Gosai, 2017 judgment, which provides a procedure to be adapted if the parties enter into a settlement or the offence is compounded under Section 138 of Negotiable Instruments Act. The Order 23 of Civil Procedure Code deals with the settlement, and which is usually adapted while the parties enter into a settlement in cases under 138 of Negotiable Instruments Act. If the parties enter into a settlement either inside a court or outside a court, the case can be accordingly disposed of in light of the settlement by recording the statement of the parties. So it is none of the issues whether the parties enter into a settlement during the trial or after the conviction or an appellate stage, because the approach is justice oriented, and it's only for the purpose of in order to provide the amount due in favor of a victim and nothing beyond.
Mr. Shakir, it was very enlightening on your behalf to educate us with respect to the stages of criminal trial in check bounce cases. We thank you on behalf of Geo National News team and for future. Also, we expect that you may honor us with your presence on other legal topics.
Thank you, Sajad, and I'm also thankful to the team of Geo National News Network. It was indeed a pleasure, and I will be always available for you for any assistance or for any kinds of concerns for future.